Good evening, everybody. Welcome to the Florida Appellate Review. My name is Andrew Harris with Harris Appeals. I am joined this evening with Jennifer Dinetz at Clark Fountain and Jeff Adelman at Brotman, Nussbaum, Ibrahim, and Adelman. Welcome to both of you. As we go forward here with these podcasts, what we hope to do is weekly or bi-weekly to bring you an overview of relevant and important cases, primarily in the field of personal injury, torts, medical malpractice, and the like. I'm going to take it away I'm going to turn it over to you, Jennifer, with our first case for our audience. Go ahead.
All right. So tonight, the first case that we'll be reviewing is Montero versus Corzo. It's out of the 3rd District Court of Appeals. The trial court was in Miami-Dade County. So very, very briefly, the case was set for trial in November 2017. The trial court had put out pretrial orders, as they typically do, saying that there's certain deadlines for all the different exhibits and witnesses to be in. In this particular case, the exhibits were due 30 days prior to the trial date in November of 2017. Now, the trial date, of course, as it typically does, got reset, and it was reset and reset until eventually it was set for August 2019. At that point, both sides had done some more discovery, and the judge had required both sides to come together and just share the exhibits that they had previously disclosed, so both sides would know what was going to be discussed and used in the trial. Well, one side decided that, hey, we just took some new surveillance a couple months ago. We never disclosed it. Now is going to be the time we disclose it. The trial court allowed this new evidence to come into trial despite objections from the other side, and despite the previous pretrial order requiring that exhibits were sent in 30 days before the initial trial date. The 3rd District Court of Appeals said, not playing with this. This was an ambush. This did violate the Binger analysis. And they sent it back down and said, this is not how it's going to roll, which is going to be important coming forward with coming out of the COVID era, where there's going to be all these trials that are going to be reset, but the pretrial orders were still in place pre-COVID. So it's going to be very important to keep note of when you have certain trial orders, and even if the trial date was pushed, the orders before are probably going to still stand based on this case. Andrew, have you seen this kind of stuff before? Do you see this coming up in the future? Are you worried post-COVID?
Well, definitely, as you mentioned, with all the continuances being granted, as much as our trial judges are going to be pushing cases to go to trial, reality hits the road, right? There are only so many cases that can go forward as we open up. What I take from this case, where defense counsel, what they should have done is move for an extension of time for the discovery period, and they failed to do that. And as you mentioned, ended up relying on undisclosed surveillance video of the plaintiff. And so had the defendant taken that simple step, it may have been granted by the trial judge, especially with the reality that the case was moved from the docket anyways. And from the plaintiff's perspective there, what would the prejudice have been to the plaintiff? Now, the plaintiff was prejudiced at trial because their experts, their treating physicians, had already given their testimony in depositions, of course. And so it actually happened during the trial there. Plaintiff's counsel moved to say, okay, judge, if you're going to allow in this surveillance, I should be allowed to ask my treating physician questions related to their surveillance. And the trial judge blocked that evidence as well. And so it was sort of a perfect storm here where now this was a plaintiff-friendly decision, but this, of course, can go on both sides. I've been on the other side as well, where I've had a new trial granted because a plaintiff has brought in undisclosed or testimony or new opinions and stuff. So this can go on both sides, I think. So for all of our members and all of our audience is, be careful when you've got new opinions, you've got new testimony about going forward, because this resulted in a new trial for the plaintiff. Any thoughts, Jeff, for you on this case at all?
It's one of those things you really, especially now, have to abide by those deadlines. And I think that the best way to deal with these things, especially with the judges, is to be open-handed. If you got it, show it. I mean, realistically, what's happening in state court is we're getting more federalized. I think Joe Cashy said that on one of our webinars, and it's true. And in federal court, you've got to disclose it. And I think that, quite frankly, it's better for justice if everybody acts that way, and we can avoid some of these unnecessary errors. that are going to make us do these cases all over again.
Any closing thoughts on the case, Jen, or?
Yeah, I just think that there's no point in hiding the ball. It becomes a much more litigious and much more unenjoyable experience. And then your client is not going to benefit. The other side's client's not going to benefit. If you're going to use the evidence, if you're going to use it in trial or in a hearing, disclose it. I err on the side of disclosure.
Right. Otherwise, what happened here, a whole new trial. If the plaintiff has a basis for attorney's fees in the case, the plaintiff can end up getting attorney's fees for the first trial and the second trial. And exactly, especially as we come out of the COVID pandemic and have all these continuances, a warning lesson for all of our members. I should have said at the outset, but all the cases we discussed, we're going to talk about 5 to 6 cases here. Try not to give too much to our audience in one sitting. They'll all be available on my website and on the Palm Beach County Justice Association website. So you don't need to take down the cases. We'll post them for everybody. The next case is one that I'm going to talk about. It is Winters versus Harper from the First District Court of Appeal from just last week. Now, this case was a plaintiff's verdict, and the defendant moved for a new trial. And the argument addressed on appeal by the First District was whether 2 mentions of insurance at trial, 2 fleeting mentions of insurance at trial, whether that warranted a new trial to take away the plaintiff's verdict. Now, the First District affirmed and held that the trial court had not abused its discretion with the 2 mentions of insurance. Now, we all know, we're all taught, right? We see the standard motions in limine. There can be no mention of insurance at trial. What's interesting here is that the mention of insurance wasn't that the defendant had insurance coverage, but that the plaintiff had insurance coverage. This was not an uninsured motorist case. It was a standard auto accident case. And the 2 mentions of insurance both came about because one of the key issues at trial was what happened at the accident scene. The defendant had hit the plaintiff's vehicle from behind, and the plaintiff and defendant both exchanged, had a conversation at the accident scene, and they had different recollections as to what had happened. Now, this issue came up actually before trial, where defense counsel told the judge that the entire conversation between the plaintiff and defendant was critical and that the jury needed to hear all of it, all of the conversation. The trial judge and the plaintiff's counsel cautioned defense counsel that if the entire conversation was going to be mentioned, one of the things which had been mentioned was that the plaintiff had told the defendant that she was leaving the scene, but was giving her insurance information to the defendant. Now, the plaintiff giving her insurance information was her own insurance, the plaintiff's own insurance. And as I said, it was not an uninsured motorist case. Ultimately, when this came up twice, the first time the defendant moved for mistrial both times, which when evidence comes in that you feel is wrongly admitted, you need to immediately stand up and move for mistrial, and you should ask for a curative. Now, the first time the insurance issue came up, the trial court denied the defendant's request for a curative, reasoning it would cause more harm to the defendant if I actually emphasize, and that's obviously a difficult balance whenever you move for a curative instruction. Ladies and gentlemen, I instruct you not to consider the fact that the plaintiff may have insurance or the defendant, that doesn't necessarily do you any good. The second time when it came up, it was actually the plaintiff's question to his own client regarding insurance. Now, but it was unintentional, and it was clear it was unintentional because you can see from the transcript, plaintiff's counsel quickly caught himself when he asked a question. He meant to refer to a phone number, the plaintiff calling his mother regarding her phone number, not regarding their insurance information. And so it was important from the appellate court's perspective and the trial judge that it was unintentional, and both mentions of insurance were unintentional. And the appellate court, very deferential standard of review here, which is what happens when a trial court denies a motion for mistrial and a motion for new trial. And so the First District upheld a significant plaintiff's verdict in the case. And it just goes to show that not all mentions, the takeaway from it, not all mentions regarding insurance will lead to a new trial. Accidents happen. None of us are perfect in trial. We can have motions in limine, which we should, and get orders in place. But an entire 4-day trial here was not undone because of the brief mentions regarding insurance. And so that's the takeaway from that case. Now, it could have been different if what had come out was the defendant having insurance. That's something which, the appellate court briefly mentioned that it was, if anything, the mention that the plaintiff had insurance may have been beneficial to the defendant if you think about it, because if a jury hears that a plaintiff has insurance, and again, it was not an uninsured motorist case, and so the information that the jury heard was not actually harmful to the defendant, and the defendant had been essentially introduced any alleged error into the case because the defendant had emphasized how important it was, the conversation between the plaintiff and the defendant at trial. So that is the takeaway from that case. I don't know if either of you have any thoughts about that, or just dealing with that issue in depositions or at trials. This aha, we all have that moment, right, where something is said, you wish it wasn't said, and you can't necessarily put the genie back in or whatever, the toothpaste back in, but it is an example that we don't have to be perfect. We're all entitled to a fair trial. Parties are not entitled to a perfect trial. So I don't know if either of you have any thoughts about this.
Yeah, it's nice when the court is human and realizes that we're all human, and when you let something slip, it's not the end of the case.
Right.
Yeah.
Not always how it goes.
Right,
Yeah.
exactly. And it was a 4-day trial. It was briefly mentioned. It wasn't discussed in closing argument. The things that courts look to, and there had been no error. And, if there had been error in the case introduced, it may have been a different analysis as well. But there was actually no error because the objections were sustained. Curative was given for the second one. And so it was just an example of why we're entitled to fair trials, not perfect trials. I will go ahead, Jeff. I'm sorry, please.
I was just gonna say, I thought it was interesting that what the plaintiff's counsel and the judge were most concerned about happened, but it just happened the other way. But it was the defense strategy to go down this dangerous tightrope. And inevitably somebody was gonna say insurance in the case. It just happened to be my good friend, Jamie Holland. And I'm glad that his verdict was upheld. But it goes to show you that this can happen to anybody. And, I'm glad that all that hard work wasn't erased over something that didn't appear to have any impact on the jury here. And it was invited by the defense.
Right. The appellate court, this is a quote from the opinion, the appellants, which was the defendants, though, seemingly failed to appreciate the role their own counsel played in this perceived problem, the perceived problem of insurance being a feature of the case. And so that's one of those examples. None of us want to be on the receiving end of an opinion like that. It wasn't that defense counsel exhibited bad faith or misconduct or anything, but the defendants were complaining on appeal about an alleged error that they introduced into trial. I will turn it over to you, Jen. I know you've got a Daubert opinion to discuss with our audience here.
A Daubert-ish, if you will.
Right.
So this is Huggins versus Siegel. Was also out of the First District Court of Appeal. It came down June 3rd, so just a couple weeks ago. There was a couple issues that were at play in this one. This is a defense affirm of a summary judgment hearing. And in this case, very, very briefly, a woman and her family, a pregnant woman, was moving into an apartment complex where they required certain mold testing to be done. And they requested it the first month they were there. They requested it the second month they were there. By the fourth or fifth month, by the time that while they were there, they finally got the testing done. The mold testing came back saying, yep, there's mold, and 2 very toxic types of mold. Pregnant at the time or around the time, she moves out and they bring a suit for negligence, private nuisance, and breach of contract. So a couple things that happen at that point. She ultimately gives birth. She gives birth to the baby that the whole time while during those 9-10 months, the baby seemed perfectly fine, had 2 kidneys, had everything was working well. By the time the baby was born, mysteriously, which is a word that was used in the opinion, only 1 kidney was, the baby only had 1 kidney, and they had a brain disorder. So of course, these were her damages, these very large damages she was bringing against this complex. And they brought in a board certified physician, Dr. Merhi, who has a specialty in infertility and gynecology. And they were going to use this expert to causally connect the issues that the baby had when they were born with the mold that was there in the apartment. And there's some timeline issues, but not to get it lost in that. The 2 issues that come about, or 2.5 issues, is first was timeliness. Now, at the time of the deposition of the doctor, there was all the information that was ultimately going to came out at the deposition. There was all these Daubert suggestions that this was not going to pass the muster test. and no Daubert motion was held. No Daubert motion was written, no hearing was held, nothing happened for approximately 200 days later. Now, when the motion was filed and the hearing was heard, it was still just barely, but still within the time period that the judge was allowing these pretrial motions. So the judge allowed this motion to go forward, and said that there was no timeliness issue. More importantly, when the judge found that this doctor was not going to be an expert for this case, that did not have the education, the training, the expertise, especially he's a board certified doctor in infertility, not in mold issues that can cause damage to a kidney being mysteriously gone out of a baby. There's also, very notably, no literature that ever talked about a mysterious kidney disappearing. So obviously not passing the Daubert test, strict the expert right before the discovery timeline was done and they were supposed to start trial. So one, found there was no timeliness issue. Secondly, what was most importantly in this case, and I know Andrew's going to just talk about this when I'm done with the summary, is that the losing side, the plaintiff in this matter, did not file a motion to continue, did not file anything to show that they were prejudiced. They're very, very prejudiced. Their motion was, their expert was gone. The one expert they're going to have to causally tie the liability issue, the mold issue, to the damage for this very, very high damages case is now gone, and they're about to go into the trial period and the past discovery period, and they have no expert. So because they had no showing of prejudice, this is what kind of killed them in this case, I would say, is my opinion. So the other takeaway on this, which I kind of alluded to, was that this doctor was not going to pass the muster test for being an expert under Daubert. His specialty was in a completely different specialty, or specific different medical field and area. There was no literature, no cases, nothing about this kind of stuff happening, these kind of medical issues happening when there's mold exposure. There was no education that he had or no training that he had that would be able to causally connect these two together. So that this is more of an extreme case of a Daubert hearing kind of harming the plaintiff in this matter. But we could see this in our everyday cases that's not so dramatic. So Andrew, I'm really interested to hear more about your takeaway about when you don't file this motion to continue, what effects that's going to have for your client and for the case.
Right. I mean, this is an example where the plaintiff essentially gambled and lost ultimately, and not to fault the plaintiff specifically here, or counsel, but if your expert is stricken and you don't move for a continuance, your only backstop is an appellate court. That's it. And so the more cautious approach here would be, one, I would say, and I know both of you can speak of this better than me as trial attorneys. I know, Jen, you handle a lot of catastrophic products liability, medical malpractice, complicated cases. Your selection of the expert in the first place is really ensuring, Daubert has been in Florida for years. The summary judgment standard is now, the federal summary judgment standard is now here. It's a really big deal to make sure you have an expert at the get-go. And when a Daubert motion comes in, and have somebody in your office review it, because sometimes we all, we pick an expert who has all the credentials in the world and means well and knows what they're talking about, and he or she is super, super smart, but may not get you there for the issues in your case. And so that's really the importance, I think, of collaboration, whether you're a solo practitioner or within, I know both of you have partners and associates at your firm or whatever, wherever, is find somebody else to give you a second look, because what happened here, as you said, the ultimate, your expert's stricken, you don't move for a continuance. The plaintiff conceded at that point that the defendant was entitled to summary judgment because there was no causation. And you take from the opinion, the trial court, if the plaintiff had moved for a continuance, I think the trial court probably would have abused its discretion in denying the motion for continuance at that point, given now the defendant timely moved for a Daubert, but just the timing of when it was heard and so close to trial. And so it's just a warning for all of us here, to not put all of our eggs in an expert who has a some shakiness pointed out by the other side, to warrant another look. Jeff, what about you? What's your takeaway from this? Because I know you have to sit down with your experts as well at the get-go, and imagine sitting there one day at summary judgment and that a Daubert motion could be coming. So
It is surprising that they didn't ask for a motion to continue it, for a motion for a continuance here. If it's denied, makes your argument a lot stronger on the for an appellate review. I am surprised that they didn't do that. I can understand how this happened, but given the credentials of this doctor, an infertility doctor for the type of case it was, I feel like somebody should have tried to press the other attorney, like, well, what happens if they say this, this, and this? Just seems like, that's probably what needed to happen. But if you were gonna press forward and you thought that it was gonna happen, at the very least, a motion to continuance, you may think it's gonna get denied. I mean, I feel like all of them are getting denied right now. It doesn't mean you don't do it, especially now, because I think there's a lot of potential errors going on right now. I mean, I was at a calendar call the other day and somebody's expert died and the judge wouldn't give a continuance. So again, you got to ask for it. It's not just about the case, it's about making a record, and hopefully you don't have to use it, but if you do, it's there. Costs nothing to do it.
I would definitely agree with especially two things Andrew said. One is getting an expert is a pre-suit activity. When you're looking at your case and you sign up your clients and you're ready to roll and you're getting things together, you're putting together your demand package and what have you. So therefore you're at the stage where you know the meds, you know the damages, you know the liability, you know what you have and what you don't have. When you're at that stage, that's when you're looking at experts. You're not waiting until you file suit. You're not waiting down the line, that because you need your experts to help instruct you as well. And secondly, if you're fortunate to have an appellate attorney at your firm, use them. If you're not fortunate to have an appellate attorney at your firm, there are appellate attorneys all around you and in this very call. So that is their purpose. That is what they're here to help you with, this trial support. Call an appellate attorney. They know what the rules are going to be if and when it gets appealed. And then they can help you through, hey, this is not going to be the best extra for your case, or it is, but these are what the things you have to do.
Very important.
The other thing from to take away from the case is that when you are, when you're faced with the Daubert motion, what I sometimes see people do is, okay, because a Daubert motion has been thrown at me, I have to turn around and file Daubert motion against the other side and think, okay, well, the judge will just deny everybody's Daubert motions. And it doesn't work that way. There are times where your Daubert motions, you shouldn't back away from filing your own motions against the other side, but it's not like a splitting of the baby example that a trial judge, I think we don't give our trial judges enough credit that they can see through the science and understand the issue. So don't think that that will overcome your deficiencies just by filing one towards the other side. And that wasn't an issue in this particular case, but I see that often happen where we have to file a Daubert motion. We have to, if you file a Daubert motion and you lose them, they're going to be used in every one of your other cases, by the way. When we file these Daubert motions against that expert has now become Daubert qualified, by that circuit court judge. And although the circuit court orders, of course, are not binding on other circuit courts, they can be very persuasive, especially when, so I would caution people from not filing Daubert motions. Don't file them just for the sake of filing them, because that won't get your case anywhere. So I'm going to turn now to an insurance case, an insurance bad faith case. Now, this is from the 11th Circuit. A lot of the 11th Circuit decisions are not published. They don't have to, unlike our Florida State District Courts of Appeal, every written opinion is published and precedent. In the 11th Circuit, there's no requirement for published decisions. This particular one was published. Well, what's the difference? It means it's binding on any other panel within the 11th Circuit versus the non-binding ones. It is ERES. I won't try and pronounce it, but maybe I will. But ERES versus Progressive was the insurance company, an insurance bad faith case brought by the plaintiff in a third party against the tortfeasor's insurance carrier Progressive. Now, ultimately, the trial court granted summary judgment to Progressive in the bad faith case, and the 11th Circuit affirmed it in the published opinion. My takeaway from this decision, and I can get briefly into the facts, is we have in Palm Beach County, but around the state, we have such a treasure of insurance bad faith lawyers right here, right within Palm Beach County, such a treasure. We've got some outside Palm Beach County as well, but retaining insurance bad faith counsel at the outset, consulting with them. It's so important not to set up a case for bad faith, not to dupe an insurance carrier or whatever, but oftentimes I find that the insurance bad faith attorneys will give you the advice, which is you're not going to have a case for insurance bad faith here. The insurance company is actually doing the right thing here. They're trying to settle the case. And so ultimately here, this was a $10 million underlying judgment, a very tragic accident. The plaintiff's 8-year-old son was killed. The plaintiff herself was badly injured and ended up with a $10 million judgment against a DUI convicted tortfeasor with $20,000 in coverage. And so I think it's really important at the outset to utilize insurance bad faith counsel, whether formally or informally at the outset. And like I said, they can bring you wisdom as to why your case can't go further, because it does no good for this family. This case, the accident was actually in 2007, and the opinion was the beginning of June 2021. So this was a 14-year case for this family, which ultimately couldn't recover, and that that didn't do any good, well, financially for the plaintiff, but obviously the emotional toll, which I know both of you can relate with better than me, with living with a case for 14 years with this family where she lost her son. But very briefly, just the bad faith facts. There was a tragic accident. Within 4 days, Progressive learned of the car accident involving its tortfeasor, offered the full limits the very next day, and it was a 10-20 policy. The plaintiff's counsel told Progressive that he wanted to await and see how the criminal proceedings went forward against the tortfeasor, and that took a couple of years. But in the 2-year period, Progressive continuously followed up with plaintiff's counsel and reiterated that they were willing and tendered the policy limits. Now, eventually, the criminal proceedings resolved, and the discussions picked up. Plaintiff ended up sending a demand to Progressive, and in the demand specifically stated that there could be no hold harmless or indemnity agreement, that the plaintiff was offering to release the tortfeasor only. Now, these are standard provisions. Plaintiff's counsel, you're entitled to that. Plaintiff wanted a financial affidavit. Plaintiff's counsel, there had been very small amount of money, but still money that the plaintiff wanted to be made whole. And what did Progressive do in response? Well, they sent a response letter, which it didn't include a hold harmless or indemnity, but it did include a subrogation provision. Now, at the time, the law was unsettled in Florida as to whether a waiver of subrogation was in the nature of a hold harmless or indemnity agreement. And that later became relevant to the lack of finding of bad faith. But most importantly, what Progressive did there is they said to the plaintiff, we're willing, if you don't agree to our proposed counter offer, please let us know with any suggested changes. Plaintiff's counsel wrote back and said, I said that there couldn't be a hold harmless or indemnity agreement. You haven't complied. Please comply. Progressive wrote back and said, well, we don't consider this to be a hold harmless or indemnity, but we're willing to strike through. Please strike through the changes in the proposed release that you disagree with. And so every step of the way there, even though there was a disagreement as to whether there was a mere counteroffer from Progressive, and ultimately the state appellate court said there had been no settlement, there had been no meeting of the minds because Progressive didn't make a mere offer, but they didn't commit bad faith, most importantly for the bad faith case. And all of their actions throughout was that they were ready, willing, and able to settle the case. Now, the appellate court, the 11th Circuit here in the bad faith decision, they properly applied Geico versus Harvey and the Boston Old Colony, 2 seminal cases in Florida from our state Supreme Court on what insurance bad faith means. But as a matter of law, there was no bad faith. At most, it was mere negligence by Progressive along the way in their claims handling process. And so, like I said, ultimately, this was a 14-year battle, which brought nothing to the plaintiff. A summary judgment in federal, a lengthy appellate process, the underlying $10 million judgment, which was affirmed, but then bad faith, which it had been removed. It was filed in state court and removed to federal court because Progressive is not a Florida citizen or whatever. And so ultimately, like I said, my takeaway from this is just how important it is to consult with insurance bad faith counsel at the outset of the case and like I said, not to set up insurance companies for bad faith, but to guide you as to whether there really is a claim, whether the insurance you want to give in your cases, you want to give insurance companies the opportunity to do the right thing. You don't want to set them up. I mean, I understand it was a $20,000 policy here, but that will get you nowhere. Our trial judges, our appellate judges take these things too seriously. There's insurance there, but when the insurance company tries to do the right thing, you won't help your client out by the long fight that ultimately had here. Now, both of you, I know in your experiences as trial attorneys, have to deal with this day in and day out. What, not so much maybe the specifics of this case or whatever, but when you are evaluating cases, insurance coverage, what are the typical things that you look for to guide you, either of you, in your cases where the coverage amount is clearly not enough to compensate your clients for their injuries?
Well, I actually had very similar to this case, and not that long ago, it was a moped versus motor vehicle case, and I represented the unfortunate man who was on the moped, very, very, very badly injured. Spent about 35 days in the hospital. First go around, went out to rehab to try to rehab, and he had to get a knee replacement and everything, and ended up back in the hospital for another 30 something days. There was a 1020 policy, and they tried to tender, and I didn't want to accept it. And the first thing I did is I called counsel from another firm, one of the treasures that Andrew was talking about. This one was actually in Miami, a good friend of our firm. And I gave them the whole rundown of what the insurance was, what the issues were, what the medicals were, if there's any potential coverage, can we explore all these other options, but essentially showing the correspondence between myself and the insurance company and seeing if there was anything that we can do so I can get some justice for my client, without screwing over the insurance company. Because in the end, which was what the counsel told me, they were doing the right thing. They saw the damages. They saw their guy was at fault. They gave what they could. There's nothing I could have done about it. And luckily we got it resolved. We were able to reduce the bills and kind of made it work within a year. So there was at least completion to this case within a year. Whereas as opposed, if I didn't take this counsel's advice, or if I didn't seek the counsel, I'd probably still be working on this case with a dead end at the end of the road.
Yeah,
Jeff, any thoughts on this from you?
Yeah, this is heartbreaking, but I mean, Jen just talked about her case. I have a case going on with a client who's very badly injured with a 1020 policy. We've all been there. We all want the coverage to be different, but the bottom line is that the insurance companies generally can see these type of things coming, and they're going to get you to a settlement conference or something, do all the things that they're supposed to do, because they don't want to face a $10 million verdict. You're not going to really be able to trick them per se, maybe once in a very long while. But again, there's resources out there, Fred Cunningham, Steve Marino, that will talk with you about your cases. I cannot even imagine what this family felt, not only losing their loved one, but then 14 years later, having their $10 million verdict taken away. We have to be careful. It's not just the money, the emotional toll is grueling for a lot of our clients.
Right, and ultimately, if we pursue these claims for bad faith where there is no basis. Now, the 11th Circuit didn't say this was a frivolous case. I'm not suggesting it was by the plaintiff there, but when there are decisions out there like that, and when those claims are pursued, they hurt all of us. They hurt all of our clients. They may lead to legislative, reform. There's been. So we need to be careful. Obviously, our sole duty is only to our particular client in front of us, but the actions that we take, whether we appeal decisions up to the state Supreme Court, up to the 11th Circuit, they can hurt all of us if we don't have the facts behind us here. I know, Jeff, you mentioned two of the bad faith lawyers. I would be remiss. Some of them we're friends with all of them, and I know they're not here on this call. But I'm just gonna. People always ask me for insurance bad faith attorneys. You mentioned Fred Cunningham, his partner, Greg Yaffa. They're terrific right here in Palm Beach County. Jeff and Olivia Liggio, Mickey Smith, Rick Ben Ruby, Todd Stewart, outside Steve Marino and his partner McCall Mueller, Brent Steinberg, Dale Swope. We have such a treasure here in Palm Beach County and around the state. I don't mean to be omitting others, but use those resources. There are no people who are more accessible and open, because not to get business, but because they've got the guidance. They do this day in, day out. It's a very niche specialty. And so take advantage of them to guide you for your clients in the right direction. Not, like I said, not to set insurance companies up, but if there is bad faith, they can guide you there, to give insurance companies the opportunity to do the right thing. And when they are doing the right thing, can give you that advice there. Now, my goal here, Jeff, was to get to your cases as well. In the interest of time, I don't want to lose the audience. We're going to save your cases for a separate podcast for everybody coming very soon. But I do want to just wrap up and thank you both here, Jen Dinetz and Jeff Adelman. We hope to do this. May not always be the three of us on. It may not be any of the three of us on. We'll have other speakers, but hope to do this weekly, bi-weekly, as I said. So thank you all for joining us this evening, and have a great night. Bye-bye.
Thank you.